Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello, great people. Welcome back to our channel. We're so excited to have you again. As Nigerians are waiting for the day that the Supreme Court will commence hearing over the issue of Fubara's suspension and some of the litigation that has been brought before it by the People Democratic Party. The National Assembly says they lack the jurisdiction to handle the case. Don't forget that the People Democratic Party has gone straight to the Supreme Court and they are making demands over their interpretation and position on the issue of suspension of similarly Fubara, if it is in the Constitution, and also on the issue of the sole administrator ruling over Rivers State and the case of emergency rule. All of these, Nigerians are waiting to see what they will say that the Supreme Court, but National Assembly, for some reason best known to them, have waded into the case. Let's look at full details of what they are requesting the Supreme Court to do at a time like this. Now, according to the news, the National Assembly has urged Supreme Court to dismiss the suit filed by 11 governors of the People Democratic Party, PDP, challenging the declaration of state of emergency in Rivers State. It's been gathered that the federal legislature, in its preliminary objection, contended that the suit was procedurally flawed and lacked merit. In a document dated April 22nd, 2025, obtained by Punch on Sunday, the National Assembly argued that the court lacked the jurisdiction to entertain the suit and called for the plaintiff to be penalized with a 1 billion naira fine for filing a frivolous and speculative case. The suit filed by the People Democratic Party governors seek to challenge President Bola Ahmed Tinubu's power to suspend a democratically elected state institution and replace it with an unelected one. The National Assembly contends that the suit should be dismissed for failing to meet legal standards. On March 18, 2025, President Bola Ahmed Tinubu declared state of emergency in Rivers State, suspending Governor Similarly Fubara, Deputy Governor Ngozi Udu, and also elected members of the State House of Assembly for an initial 6-month period. Following the suspension, Tinubu appointed Rear Admiral Alibawe Tiba as retired as the sole administrator to oversee the state affairs. The National Assembly had rectified the president's declaration through a voice vote, but the PDP governors are challenging both the powers of the president and the process used to approve the state of emergency. In a suit SC-CV-329-2025, the PDP governors from Adamawa, Enugu, Osun, Oyo, Bauchi, Akwa Ibom, Plateau, Delta, Taraba, Zamfara, and Bayelsa State approached the Supreme Court to challenge the president's authority to suspend a democratically elected state government and replace it with an unelected appointee. The plaintiffs seek the court's determination on several constitutional issues, including whether the president can lawfully suspend or interfere with the offices of the governor and deputy governor, and whether the National Assembly approval of the state of emergency through a voice note contravenes constitutional requirement for a 2/3 majority. The plaintiffs in the suit are seeking the following declaration. 1. That the president cannot lawfully suspend or interfere with the offices of governors and deputy governors or replace them with unelected appointee under the guise of a state of emergency. 2. That the National Assembly cannot approve a state of emergency declaration by a simple voice vote without a 2/3 majority. 3. A perpetual injunction restraining the defendants from interfering with state offices through the state of emergency proclamation. 4. An order nullifying the state of emergency proclamation in Rivers State as published in Official Gazette number 47 on 2025. The governors are asking for an order of perpetual injunction restraining the defendants from suspending or approving the suspension or in any way interfering with the offices of the governor, the deputy governor, and or the House of Assembly of any of the plaintiff state by way of proclamation of state of emergency or in any manner whatsoever or by any method howsoever. An order setting aside and nullifying the Official Gazette number 47 of 2025, State of Emergency Review State Proclamation 2025, made by the President of the Federal Republic of Nigeria and wrongly approved by the second defendant, and upon which the ominous threat by the first defendant against the plaintiffs is predicated. However, in the preliminary objection, the National Assembly faulted the plaintiff's suit and urged the Supreme Court to dismiss it, arguing that the court lacks the jurisdiction to entertain the case, particularly against the second defendant, NASS. Declaring that it holds a memorandum of conditional appearance, the National Assembly argued that due process was not followed in instituting the suit, emphasizing that the plaintiff failed to issue the statutorily required 3 months pre-action notice to the clerk of the National Assembly as mandated under Section 21 of the Legislative House Power and Privileges Act 2017. Accordingly, it stated, and I quote, it said, a person who has a cause of action against the Legislative House should serve a 3 months notice to the office of the clerk of the Legislative House disclosing the cause of action and relief sought. Additionally, NASS argued that the plaintiff did not secure resolution from their respective state houses of assembly, a prerequisite for approaching the Supreme Court under its original jurisdiction provision outlined in the Supreme Court Original Jurisdiction Act 2002. Citing alleged trade reference in the plaintiff's suit, which borders on the statement attributed to the Attorney General or during a press briefing, NASS noted that since the trade did not emanate from them or their offices, the suit has no business with them. Accordingly, said that the objection read, considering the affidavit in support and the trade alleged which did not come from the second defendant, that's National Assembly, there is no cause of action against it. This is a suit relating to an alleged threatened declaration or proclamation of a state of emergency in the plaintiff states by the Honorable Attorney General and Minister of Justice. This is allegedly as a result of the statement of the first defendant in a press briefing held March 19, 2025, wherein he said to have stated that after Rivers State, it can be anybody's turn tomorrow. None of the alleged threat or statement is alluded to the second defendant or any of its officers. The National Assembly further contended that with the objection amongst others submitted, due process of instituting the action in the suit was not followed by the plaintiff before taking this step against the second defendant, as the plaintiff failed to issue the requisite 3 months pre-action notice to the clerk of the National Assembly and took no step to obtain the resolution of the houses of assembly of each of the states to enable the plaintiff each join to approach this busy court pursuant to the provision of the Supreme Court Original Jurisdiction Act 2002 on the matter. NASS asserted that the plaintiff were attempting to use the Supreme Court to dictate how it exercises its constitutional rule, particularly regarding the use of voice vote to rectify state of emergency under Section 305 of the 1999 Constitution. The objection described the suit as speculative and an abuse of court process. It further stated, it said that in the suit, the plaintiff seek to use the court to curtail the manner in which the second defendant, that's NASS, vote or make approval to rectify proclamation of state of emergency declared pursuant to Section 305 of the CFR in 1999 to get the 2/3 majority of their vote. It also seeks that the court dictate how much rule are to be performed by the second defendant, that's NASS. The suit seeks to restrain the second defendant from using voice vote to gain majority approval for the future of anticipated proclamation of state of emergency in the states of the plaintiff. The suit also seeks by perpetual injunction to restrain the second defendant's houses, that's Senate and House of Assembly, from carrying out their constitutional duty of approval or proclamation of state of emergency, and seek that the approval given by the second defendant on the 20th day of March 2025 rectifying the proclamation of state of emergency in Rivers State be set aside for being wrongfully approved. NASS further stated that the second defendant stroke applicant have observed the several deficiencies in the suit of the plaintiff which goes contrary to the provision of the laws, and the jurisdiction of the court raises objection and submit that the 11 states plaintiff approached the court wrongly and in abuse of court process. It predicated its objection on 6 grounds, stating that the plaintiff's suit lacks a cause of action. National Assembly further stated that the plaintiff lacked locus standi to proceed against the second defendant on the issue raised in the suit. It also argued that the plaintiff failed to comply with due process to stipulate under Section 2, Schedule 2 of the Supreme Court Additional Original Jurisdiction Act 2002. The second defendant noted that the court lacked jurisdiction. In an affidavit supporting the notice of preliminary objection, a legal officer in the Directorate of Legal Services in the National Assembly, Godswill Onyebu, argued that due process was not followed to institute the suit. Onyebu maintained that no dispute exists between the plaintiff and either the government of Nigeria or the second defendant, NASS. Hear that again, he said, the Onyebu, who is one of the legal officers in the Directorate of Legal Services in the National Assembly, that he maintained that no dispute exists between the plaintiffs and either the government of Nigeria or the second defendant, NASS. He further deposed that the plaintiff did not obtain the required resolution from the Houses of Assembly in their respective state to authorize the suit under the Supreme Court original jurisdiction. There is no cause of action against the second defendant, or as no threat emanated from the second defendant's office, that the plaintiff lacked the locus standi to institute this suit, as none of the plaintiff has shown that it has suffered anything far and above any other person or people of Rivers State. There are no disputes involving question of law or fact upon which the existing or extent of a legal right depends between the party. The plaintiff have not established any legal right against the second defendant to warrant equitable relief such as perpetual injunction. He noted that the Supreme Court lacked jurisdiction to hear the matter against the second defendant as constituted. In addition to requesting the dismissal of the suit, Onyebu called for a cost of 1 billion naira to be awarded jointly and severally against the plaintiff in the interest of justice. According to him, he says that the plaintiff state's Houses of Assembly did not pass any resolution by a simple majority of the members present and sitting at the time of the resolution authorizing the plaintiff to institute this suit, that the plaintiff have not established any legal right against the second defendants to enjoy the equitable remedy of perpetual injunction, that the suit of the plaintiff is speculative, unfounded, frivolous, and vexatious waste of resources, time, and energy of the second defendant, that the present court lacks the jurisdiction to entertain this matter as presently constituted against the second defendant, that it is the best interest of justice for the court to dismiss or strike out this suit against the second defendant with a cost of 1 billion naira only, jointly and severally against the plaintiff. That was what the affidavit said, and a lot of reactions have trailed this particular move, based on some of the points that they have raised, that the Supreme Court lacked jurisdiction, to go ahead with the case. Let's meet in our comment section. What's your standpoint on the objection raised by NASS against the suit instituted by the 11 PDP governors as against the emergency rule in Rivers State and the suspension of